As Ava said, the National Crime Victim Law Institute is a partner in this work. Our expertise is around victims' rights. And so we're super excited that with NOVA, we're expanding the understanding of what victims' rights are and what it looks like in the military and civilian systems and how we can partner. That through line from Ava's training all the way through the end of this multi-week series is going to be about how we partner to serve military connected survivors. So just as Ava said during her training, we don't expect you to become experts in each piece that we share. That's true for mine. What I think we're hoping everyone will become not an expert in, but 150% committed to is partnership, because you're going to learn from a lot of different folks, both those of us that have the privilege of presenting and each of you in chat. And if we partner and share expertise, we can serve military connected survivors. So I share that because now I'm going to just share a little bit more about what NCBLI's expertise is, because it's one little piece of the puzzle. It's an important piece, and I love my piece, but it's one piece. The National Crime Victim Law Institute, as I said, is based in Portland, Oregon. And we are predominantly a legal service provider and technical assistance provider to other legal service providers. We work across all justice systems, civilian, military, doesn't matter. Whether it's civil or criminal, doesn't matter. What we do is work to reestablish the survivor's independent voice in those systems. Very often in our justice system, survivors' voices are co-opted, sometimes intentionally, sometimes not intentionally, by either persons or process. What I mean by that is, think about the criminal justice system. Oftentimes we literally hear, if you have that capacity, see or read about the prosecutor saying something about what the victim thinks, about what the victim feels, about what the victim hopes for. And how many of you, just use chat, how many of you have worked with a survivor who has told you, what's happening in the criminal justice system is not quite what I want? Use the chat or raise your virtual hand. Yeah, always a lot. Yes, yes. Yeah, our criminal justice system in particular has been designed, I want to rephrase that. It was originally designed, quite honestly, and there's a whole training that NCBLI does on the history of our criminal justice system. It was originally designed to allow survivors to have independent voice in the system. Now, there's a big caveat on that, because it was only some victims, because our criminal justice system was established at a time when colonialism was the methodology of the day and was intentionally, right? It still is present, colonialism. And racism was an accepted practice, very publicly accepted practice, because our criminal justice system was established during slavery, right? And so only some victims were in the well of the court, but the structures of our system and the origins of our system actually had the survivor in literally the well of the court, being the one who spoke to the judge. We evolved away from that. And it became such that the prosecutor was completely in charge of the voices that could be heard in that system, the prosecutor and the judge, right? And the defense, of course, has their own lawyer, and their voice should be, and by law has to be, heard in the system. But the victim's voice started to be eroded and owned by someone else. So victims' rights came into being in the 1970s and 80s in our civilian jurisdictions, and more recently in the 2000s in our military jurisdiction. to return the victim to a place in the system where they had legal standing. That's a term, but what it means is the ability to speak directly to the court about what their hopes and rights and desires are. NCVLI's entire mission is about returning to survivors the agency that they should have in that system. And we do it through legal advocacy, education, and resource sharing. This partnership with NOVA is incredibly important because this military connected piece, we had been working on victims' rights in the civilian system for decades. And it wasn't until the military really turned a focus, and originally it was on sexual assault in the military, right? The military turned its focus to sexual assault in the military. And if we're being very transparent and understanding process, it was Congress that forced the turning and the focus on sexual assault in the military, that victims' rights in the military started to come into fruition, started to come into being. And that's when NCBLI got involved, because before that, our expertise of lawyers for victims didn't have a huge role to play in the military. But in 2013, NCBLI partnered with the Air Force to design and stand up the Special Victim Counsel Program. It's known as the SVC in the Air Force. Now it's the Victim Counsel in the Air Force. They changed their name. Some of the branches, it's Victim Legal Counsel, VLC. And so NCVLI worked with the military to say victims should have their own lawyer, which is what NCVLI does on the civilian side, their own lawyer to help them navigate criminal justice processes. So I share all of this to really ground you in what is my expertise, what is NCVLI's expertise, and to start hinting forward at what we're going to do in our time together. More specifically, what we're going to do in our time together is try to identify key victims' rights in the military and civilian justice systems. So a little bit of comparison. And each of you likely has expertise in some of these spaces. So I'll be using chat quite a bit, and we'll do a few polls. We're going to explain the role of victims' counsel more than I already have, looking at what it is in the military and the civilian side. And then we're going to try and articulate the intersection of victims' rights and reporting options. So Ava talked in the last session about restricted and unrestricted, and there was an incredibly robust chat conversation happening about restricted and unrestricted reporting. We're going to dig back into that just a little bit. And in terms of the flow of our time together, I get to work with you for the next just under 2 hours, I should say, so that you know how this is going to unfold. As I started to work with the military in 2013, I realized, there's a cultural moment in a lot of military trainings, and I want to share that with you, which is approximately every 50 minutes, 50, in a military training, that's when you take a break, right? So as Ava was starting to give us little cultural moments, I'm going to abide by that. So at the 50-minute mark, or as close to that as I can in my session, we'll take a break. Okay, so you can start to get ready for that. And then I will finish up my content. And then the last 20 to 25 minutes together, we're going to do a hypothetical. Now, the hypothetical is the exact same one that you have in your materials in the online student portal that Ava mentioned and that you received an email about. And I'm going to explain and read aloud that hypo, and then we're going to do some exercises around it. And that's the start of using that hypothetical in every session moving forward. Okay, so that's the flow of our time together. Put questions in chat at any time, and we'll work through those hopefully along the way. If I miss it for some reason, put it in again, and I'll try to catch it. It's on my screen, and we will try to learn together over the course of our time together. Okay? All right, so our first moment of, and I love the chat that is happening, which is about how to manage expectations and about where the control exists in the criminal justice system and not. So I'm super grateful for the conversation that is happening in chat about explaining process to victims. Okay. So on the screen right now, and this is going to be a chat interaction, on the screen right now are 3 ways of writing the topic on which I'm speaking. There is victims' rights with the apostrophe before the S. There is victims' rights with the apostrophe after the S. And there is victim rights with no apostrophe. Which one of these resonates most with you? Put in chat. Which way resonates most with you and why? If you don't mind putting that in chat. Which one and why? Great. I'm seeing lots of options here. I just saw one that went by. I'm not going to read all of these because there's no right answer. We all have moments, but someone put in this lovely answer just a few moments ago. It says, all of them, it depends on the situation. And I really want to emphasize that because each of these has unique meaning, and choosing which one you use in a moment with intention really matters. And what do I mean by that? Several of you have put in that the apostrophe matters, right? In Western European traditions of how we write English, the apostrophe can mean a contraction. I do not know can become I don't know. You use the apostrophe to make it a contraction, shorten words. But in this context, the apostrophe means ownership, right? An apostrophe starts to create the notion of ownership. And in law, ownership of rights matters. So when I write, and I'm going to go backwards on my slides for just a moment, the first one, victims' rights, where the apostrophe is before the S, that is a notion of an individual victim owning their rights, right? This matters in victims' rights because if someone owns their rights, whether they're an accused, whether we're talking about environmental rights, whether we're talking about LGBTQI rights, if someone owns the rights before they can be acted upon, or before you can do something that diminishes them, you have to ask the person, what would you like to do with your right? That's so powerful, right? When we think about an accused rights, if they have a right, the system has to pause and ask them whether they want to assert it or waive it. If we're talking about ownership, you can't see because I have my screen bar, but I'm holding up my phone. I own my telephone, right? Before you take my phone, because I own it, I have an apostrophe, Meg's cell phone, you would have to ask me, Meg, may I have your phone? Because if you don't, you stole it from me, right? So the first one is about the individual human being and that we have to ask them about their rights. The second one, S apostrophe, that's when we're talking about the movement, the notion that we're going to work on behalf of all victims to improve rights. I wear that hat a lot because I work on legislation. I work around the country in order, yes, Meg Garvin's presentation is ownership. That's really funny. That's in chat. Sorry, everyone. I work in legislation where I'm trying to work on improving the rights of everyone. That's when I'm using plural rights. Or sometimes as a lawyer, I have more than one client in the same space, and I'm working on behalf of both of them or all of them. The last one, victim rights, that is a historical legacy of how we used to talk about it most, where victim was more of an adjective on the rights. It's not wrong, but with a lot of intention, if we focus on, again, that apostrophe, we can start to ground ourselves in why it all matters. What we need to do to make the rights as meaningful as possible, to start to empower survivors in the very systems that had erased them for a while, or which had co-opted their voices. So I'm starting here with this, what might seem for some of you is a really basic proposition, but I think the field of victim services has sometimes not taken as much ownership over the legal space of rights that we can. And if we as a community, as partners, can start to say, wait, the victim owns that right to privacy, to be present, to be heard. The system has to wait and ask them what they want to do with it. If we can get our mind around that ownership of rights, we can create a lot of change. So my entire focus and NCVLI's entire focus is putting that apostrophe back on victims' rights. My brothers, I'm the youngest of 6 children, and my brothers often ask me, what do you do? Because they don't know, and we're a very sarcastic family. And I've told them before, all my job is to put the apostrophe back on rights. That's it. That's all I do. And my brothers sometimes poke fun at me and say, really, that's all you do? That's so simple. And I said, yeah, but you step into our criminal justice system, right? And try to make them see the apostrophe. It's not easy, but it is so critical, right? Survivors need to have power again for some of them, and for some of them have power for the first time, and we can partner to do that. Okay, so why does it matter at all? It's because we know from decades of research that empowerment helps with trauma recovery. There is so much research around this space. And what's really interesting is in the legal field, most of that research has been done around an accused person. Equally important, right? An accused rights as a victim's rights and a victim empowerment. But we left the research with the accused. And what I mean by that is in the 1970s and 80s in the legal field, there was just a burgeoning research field around what's known as procedural justice. And that field of research in law said, we need to improve our justice systems because what we're seeing is when someone feels empowered and heard, and the someone in the research was the accused, they have more faith in the system, even when the outcome is not what they would have hoped for. So the notion of voice and choice in process leads to increased faith in system. That was what the research told us in the 70s, 80s, and 90s. But we labeled it procedural justice and only focused on the accused. While an entirely separate set of research was being done around victim experience. And I have on the screen Dr. Judith Herman's not original book, but one of her early books, Trauma and Recovery. Raise your virtual hand if you've read this. Yay! I'm so excited when I find the shared books, right? It's just one of those lovely moments to me. And I'm all of a fan also of folks sharing reading because we can learn from each other's readings. Judith Herman has done just amazing work around this space. And in this book, she talks quite a bit about trauma, focusing on psychological trauma. And this quote on the screen is one of the more impactful from my perspective, right? That the core experience of psychological trauma are disempowerment and disconnection. Recovery, therefore, is based upon empowerment and new connections, right? So if we can return the apostrophe, we are empowering. And the research tells us when we empower, trauma symptoms go down, resilience can thrive, and hope begets hope, right? All of those things. The science of hope teaches us this too. Judith Herman has taught us when we put procedural justice notions together with the science of hope and Judith Herman's research, our core job is to empower survivors. That is the core of advocacy, whether your job title is victim advocate, victim witness coordinator, law enforcement, right? Attorney, it doesn't matter. If you're in the space to serve survivors, to be survivor-centered, to have the core of our work means that we empower survivors so that they can choose the doors that matter to them and that are correct for them. One of the things you'll hear me say over the course of our time together and in all of our trainings is we work towards victim agency, not just victim autonomy. So autonomy is a lovely idea. It means that you get to choose from all the options in front of you. The legacy of the idea of victim autonomy, however, comes from a very structured and patriarchal approach to understanding human beings. Agency, on the other hand, is the notion that you get to create the choices and then choose, not just choose from what's put in front of you. So everything around victims' rights, everything around the apostrophe, everything around partnering to empower is about ensuring that we're helping survivors create paths and choose paths. Sometimes those paths are turning towards our systems, and sometimes we are empowering survivors to turn away from our systems. And those are both beautiful options for survivors. And in between, there's myriad of paths. So victims' rights is not about always being in the system. Sometimes it's about being empowered enough to turn away from the system. Okay, we have our first polls. So this is a different way of engaging. And so I'm going to ask that just poll 1 come up first, if that is okay. So here is poll number 1. If a crime is committed by a military member against another military member or civilian, prosecution must happen in the military court. True or false? Now, some of you will know this, some of you will be guessing at it, and some of you are like, I'm not comfortable guessing, because we're just starting on our learning together. So it's okay. If you already know the answer, that's because you're coming into the space with expertise. If you don't know the answer, it's because we're starting to build our collaborative knowledge. Okay, let's share the results, end the poll and share the results of where we are. Okay, so 37% of you said true, that it must happen in a military court. 63% said false. The answer is false. Okay, if a crime is committed by a military member against a military member or civilian, prosecution can happen in civilian or military. We're going to unpack that. Again, starting to learn how to ask the questions around this space helps us be like, oof, maybe my survivor has more or different choices than I thought they did. Let's launch poll number 2. A victim of an offense committed by a military member can report to either civilian or military authorities. True or false? Okay, let's close the poll and share those answers. All right, 93% of you said true. someone can report their victimization in either space, civilian or military, even if it was a military member who committed the offense. That is correct. It is true. Now, where you report can have ramifications, right? Both on how confidential you can keep information. Again, we'll get back to restricted and unrestricted, right? What it means to report. It also, just because you report in one space or the other doesn't say who's going to take over the power of prosecuting, right? The victim's reporting choice, if it goes unrestricted in the military, does not dictate who carries forward the prosecution, the investigation or prosecution. This is all part of a concept known as jurisdiction. Again, not asking folks to become lawyers, right? This word jurisdiction gets thrown around a lot. Not asking you to become a lawyer. And, right, law sometimes is just about vocabulary, right? I paid to go to law school to learn a vocabulary. That's predominantly what I learned. I love it, but it's a vocabulary. So jurisdiction is a word to get to know a little bit, because what jurisdiction means is who has authority to investigate and then judge behavior. That's basically what it means. Where is the power to investigate and then move into court and judge behavior, right? In terms of military crime, there's really two major elements to determining jurisdiction, and that is where the crime takes place, on base, off base, and whether the accused is active duty service member or not. And active duty can be, if you're a reservist, just your reserve weekends, you're active duty on those weekends, right? So those factors become how we start to analyze jurisdiction. And then there can be what is called concurrent jurisdiction, which is when both military and the civilian have jurisdiction, power, which means power, over the conduct. In those moments, there's a lot of negotiation that happens between the military and civilian to decide where is this case going to move forward. And I absolutely appreciate what's in the chat, right? Or deployed as a National Guard or reservist, that makes you active duty too, right? Really starting to know, again, don't think you need to become an expert on the details. Start to think about what are the questions I might need to ask in order to open up opportunities for choice and power for the survivor I work with. So one of those questions is, who has jurisdiction, right? Who has jurisdiction? And why does jurisdiction matter, right? There's a lot of reasons why jurisdiction can matter. A couple of them, I want to pause because there's a very important point in chat. The victim has no say if there's a negotiation between the civilian and military over who might move it forward. That is generally accurate. And I would say, as we've started to have more and more lawyers in the space for victims, both civilian and the SVC, VLC, VC, that victim counsel program in the military, those lawyers can be active in that negotiation. OSTIC, the Office of Special Trial Counsel, which is the newest, it was stood up and started taking cases in January of this year. They're actually the prosecutor. They will be involved, right? Trial counsel is the military's vocabulary for prosecutor. The Office of Special Trial Counsel, or OSTIC, which was mentioned in the chat, is the new office that is taking over all of the most serious crimes, particularly those that we're talking about in this training, sexual assault, domestic violence. They are the prosecutor. So trial counsel in the military means prosecutor in your civilian vocabulary brain. They'll definitely be involved in the negotiation to give victims voice in this space. Sometimes they'll be able to support the victim's preference, but having a victim's independent lawyer in the space also can help support the choice, right? But again, it ends up being a power-to-power negotiation. So that comment is correct, and I wanted to say where some advocacy could happen. So in military jurisdiction, I'm not going to go over the details on this slide. In the materials that you will receive, and I believe they're already in the student online portal, there's a lot about jurisdiction, right? There's a lot of how do we know what's happening. But in the military system, there's general court-martials, summary court-martials, special court-martials. That's what that 3 types of court is referencing. There's also things called administrative separation, non-judicial punishment. Lots of ways that the military has set up to deal with different types of behaviors, some which look like our civilian criminal system, and those are those court-martial processes, some which look more like our employment law. That's the administrative separation type pieces, because military members are also employees and there's an interesting relationship there. Some of which look like a little bit more like employment, but it's where it's non-judicial. The commander can do certain reprimands without going through either process. OSTIC has changed that a little bit and has removed some levels of authority, but for instance, pretrial confinement, holding someone is still a commander's authority. Again, you don't need to know all the details, and some of this will be in your written materials, but starting to know, oh, different things can happen. There can be concurrent jurisdiction, right? There can be times when a survivor wants to go one direction or the other, and maybe there's some advocacy that can happen. And maybe I need to find out who I can partner with for that advocacy. I've been working with military connected victims and in military courts, like I said, since 2013. I would never go into a military court without a military partner. I have a lot of knowledge and I would never do it because I don't have enough. I need a partner, right? So again, this is teaching you about jurisdiction is just to be like, there might be choices. How do I find a partner to help me understand those choices so I can help my client, my survivor? Okay, let's move a little bit more into the rights, into the knowledge here. And so we're going to do first poll number 3. All right, victims have legal rights in the military criminal justice system. True or false? Okay, let's share this one as votes quickly are coming in. 97% of you said true. The answer is true. I'm going to share some of what those are in just a minute. All right, let's go on to the next poll 4. So this is the flip side of the question. Victims have legal rights in the civilian criminal justice system. And I see lots of you doing it in chat also, which is fantastic. Okay, let's close this one. Trick question. I appreciate the chat around trick questions. So 97% of you said true on this one also. The answer is true. So now let's unpack that. What does it mean? Every jurisdiction is different, right? There are numerous sources of rights. We don't always look at all of them. And even as a lawyer, you're not seeing the poll questions, only the side that says poll. So Annette may be able to troubleshoot that with you for the next one. And I'll try to slow down my reading of the poll so you could answer in chat. For the individuals who said that, I apologize. So sources of rights. In law, rights come from various places where we have written down law or where courts have created law. That's what is known as common law. We are a common law country, which means your rights can come from written things or when a court speaks. Okay? So the most common places that you can find rights are the US Constitution. That is the highest level of right you can find, meaning it is the strongest level of right. State constitutions, state statutes, state rules, and case law. Those are all the places you can find rights, including victims' rights, if you are going in a state jurisdiction. So if I went outside right now and someone had hit my car or vandalized my vehicle, I'm in Oregon. There's no federal connection for that. So I would be looking at, do I have any rights under the US Constitution, under Oregon's Constitution or statutes or rules? If I was at a national park and my vehicle was vandalized, because national parks are federal land, I would be on the right side of this screen. Federal statutes, rules, and case law. And case law, again, is when a court speaks. Okay, that's, again, known as common law. So you can find rights in all these places. Sometimes they say victims' rights, and it actually labels it. Other times, it just is a right. And the biggest example of a right that victims have that is not labeled a victim's right is the Fourth Amendment. How many of you know what the Fourth Amendment is of the US Constitution? Raise your virtual hand or type chat. The Fourth Amendment to the United States Constitution. What is that? Does anyone know? The Fourth Amendment to the US Constitution says you can't be subject to an unreasonable search or seizure. Yes, search or seizure. This is the one that I intentionally put the number on it, Fourth Amendment, because many of you wouldn't know that part. But if I just said, can police officers just search your car willy-nilly, right? Most of you would say, no, they're not supposed to, right? And yes, it happens, and we have to fight for that. But the Fourth Amendment says no one can be subject to unreasonable searches or seizures. And this is where, when law enforcement has to get a warrant, it doesn't say an accused person has that right. It just says all persons, which means victims have the right not to have their things searched. Right? The cruel and unusual punishment, that's the Eighth Amendment. Nice. I love that people are putting in other rights out of the US Constitution. It's brilliant. So there are rights everywhere. No, don't say sorry. It's brilliant. Like you're searching all of your wisdom and trying to think, how can I put it in this space? And that's what advocacy is. And then we learn, oh, we'll use that one later. And there are opportunities to use that one later too. So there's lots of places to find the rights. I'm going to give you two big examples because they directly impact victims in the military. The first one is what is known as the Federal Crime Victims' Rights Act. This was passed in 2004, and it is about any crime that is committed, and it falls under federal law, so federal jurisdiction. So this would be on national parks, on federal land, interstate travel, those kind of moments. These are the rights under the Federal Crime Victims' Rights Act: to be treated with fairness and with respect for the victim's dignity and privacy, to reasonable, accurate, and timely notice, to be reasonably protected, to not be excluded, to confer, to be reasonably heard, to proceedings free from unreasonable delay, to full and timely restitution, to be informed of plea bargains or deferred prosecution agreements, and to be informed of all of these rights. Every state in this country has rights similar to these. Not identical, but similar. The military has also passed rights. More recently, the CVRA was 2004. The National Defense Authorization Act of, I think it was 2011, someone correct me in chat, adopted the Federal Crime Victims' Rights Act and said, hey, you know all those rights that we passed into law for federal crime victims? Military victims should have them also. And so what are known as Article 6B rights came into being. And those are the ones on your screen. They are very similar to the federal rights. And I love the chat that, wait, what is this word reasonable and reasonably, right? Doesn't that minimize or diminish the rights? Because the actual quote is reasonably is a love-hate word in this context. Brilliant, right? That's a great framing because we have to argue about what is reasonable. Is it reasonable to not notify me until 24 hours before a hearing? Maybe me, who has technology and could appear virtually, was it reasonable for one of my clients who actually, this is a true story, had become a paraplegic because of the shooting and now lived in a different state, and they gave 24 hours notice that they could be present at a hearing? No, right? And so we litigated it and said you had to postpone the hearing, right? So it is a love-hate relationship, right? But you have to argue about it. But these rights exist. They exist in state constitutions, state and federal statutes, in rules. And then as we litigate, we create court-spoken rights, common law. The rights are still super new. Yeah, I love this point, Jamie, that you have in the chat. They'd say it's still a notification, and it's very sad that they don't take into context true situations. Again, what I will share is as victims' lawyers are becoming more prominent in the space, and we're still new, we're able to litigate that and say the legal standard has to be higher, and we have had success. And we're just starting to do this with military-connected victims. Civilian victims, we've been doing it since about 2003, right before the Federal Crime Victims' Rights Act was passed. Military, it's only been since 2013. So this is all new, how we make these rights more powerful, more meaningful, not just words on paper. That's a totally new experience in this community. And we have to partner to do it because as a lawyer, I won't see all the issues. Right? I need to partner with an advocate, a social worker, a hospital, right? Law enforcement, prosecutors, right? To return to the system the actual voice of the survivor. So on the screen is just a screenshot of a PDF that is in the student center. And if it's not in there, we'll add it. What we started to do is create little handouts, one-pagers, about the jurisdiction's rights that exist. So that you would have just easy access to both what is the military right and then what are your state rights for victims. We didn't do all 50 states because we weren't always having all 50 states on these trainings. If you ever need to know what rights exist in your jurisdiction and how strong they are, NCBLI will do technical assistance around that and work with you just generally or on a specific case. And all that information will be at the end of this training so that you can get it. But these are in the resource materials. So victims' rights can be really complex. And it is just like, how many of you have ever had to or had the privilege of buying or selling a house? Raise your virtual or physical hand or put it in chat. The privilege or challenge, right, of buying or selling a house. Yeah, many of you, right? Not all of us, because it absolutely is both a privilege and a challenge to purchase or sell a home. And the length of the materials you get to read, to sign, right? The paperwork. hundreds of pages, hundreds of pages. I'm a lawyer. I don't understand any of it. I don't understand any of it. If I had a challenge with any of that, I would hire a real estate lawyer, right? If I have a problem at my job, I will hire an employment lawyer. Victims' rights or victim law is its own area of law. And so there is no expectation that any of us will know all of it, nor is there or should there be an expectation that every lawyer will know it. But again, we need to partner, right? There are victims' rights lawyers in the civilian side and in the military side, and they have developed an expertise around just this space. How do you take rights and use them in the criminal justice system? How do I take a victim's rights and litigate? I'm not the prosecutor. I'm not the defense attorney, but I, Meg Garvin, can argue on behalf of my clients in a criminal case in the military system and in the civilian. In the military system, victims' lawyers are called special victim counsel, victims' legal counsel, or victims' counsel. Different services, different branches call them something different. They all are similar. On the civilian side, they're called victims' rights attorneys or victims' counsel. Yes, I see the chat. Advocates need to ascertain our trainings into university degrees. What I will say is advocates sometimes know more law than many of our judges. So I know this is being recorded. I'm okay saying that because I firmly believe it. So the lawyers are in this space to really, again, empower victims to take these rights and to advocate in court in a way that only lawyers can. The court system is set up for lawyers. It is set up for lawyers to argue law on behalf of clients. So, what does a victim's rights attorney do? I'm going to tell you a little story about the first time this happened in the military, and then we're going to take our break. Okay? LRM versus Kastenberg. This is the case in 2013. CAF, so let me just do a little bit, again, adding to your degrees. You might see things written out like this as you work with victims. I want to tell you how to read what's on the screen. LRM v. Kastenberg, that's the name of the case. The V, that's the versus. The name before the V is going against the name after the V, right? Sometimes it says state versus defendant. LRM in this case was a victim. Kastenberg was the name of a judge in the military who wasn't honoring the victim's rights. This is the way you would caption, that's what it's called, a case when you're asserting your rights. I ate peanuts. And it went down the wrong pipe. I'm truly sorry for that, everyone. Then there's a comma, and then there are numbers. The first number tells you what volume of book something is written in. Old school, but you can find it online. The next set of letters will be the name of the book, Military Justice. The next number is the page number. Where do I open the book to? Then you'll always see parentheses. And in the parentheses is the court where this happened and the year. CAF is Court of Appeals of the Armed Forces, 2013. This case is about LRM, a victim of sexual assault, who wanted to be heard about what is known as Rape Shield. Her prior sexual history was about to be talked about. She wanted to oppose that through her own lawyer. And the judge said no. So she brought an action to enforce her rights against Kastenberg, the judge. And the case was decided by the Court of Appeals for the Armed Forces in 2013. So that's how you read what's on the screen. What is behind this case is this case happened right after the Air Force stood up its Special Victim Counsel program. No one knew what a victim's lawyer could do in the military. But the rights on paper said that the victim had the right to be treated with dignity and with respect for her privacy, and that prior sexual history, which is known as rape shield laws, said prior sexual history should not come in to the case. And so LRM had a lawyer, a special victim counsel in the Air Force. And LRM and her lawyer talked and said, I want to oppose them bringing into evidence anything about my prior sexual history. And LRM's lawyer said, okay, that is your right. I'm going to go argue for it. No matter what the prosecutor said, no matter what the defense said, no matter what the judge said, LRM's lawyer, Captain Dilworth at the time, said, I'm your lawyer. You have rights. Here we go. And went into court. And the first moment in court, Captain Dilworth, the SVC in this case, was pretty much told to be quiet. Maybe even told subtly to shut up. Because it was new, victims hadn't had lawyers. But the SVC, Captain Dilworth, and his client, LRM, said, but it's my right. And so I'm going up on appeal. And they took the case up to CAF. And CAF, the Court of Appeals for the Armed Forces, the highest court, said, oh yeah, the rights are there. And a victim can have a lawyer. And that lawyer gets to speak in court no matter what anyone else says. And so the victim got to oppose them talking about her prior sexual history. Now, did she win on everything? Keeping everything out? No, she didn't. But she got to be in the fight. And she got to be the one that said what she wanted and not have it co-opted by someone else, right? LRM had a victim advocate who helped her work with the lawyer, right? The lawyer worked with the advocate to support LRM, but all of it was about the apostrophe. What does LRM want? It was absolutely outstanding for her. When we come back from break, I'll share an example of the civilian, so you see it working in the civilian too. And the question in the chat, how does the appeal work? Does it happen during the current case? Can it pause things? So it did happen during the current case, right? It is what is known as an expedited appeal, usually the way the law is written. On the civilian side, it can happen very fast because the law is very clear about taking a case up to an appellate court. The military, we are still working on the legislative side about how fast it can happen and how far a victim can go. For those of you that are already deep in the weeds and know this stuff, I'll share one tidbit about this case that others you don't need to retain. The issue in this case was actually certified up to the CAF by the Judge Advocate General, which is a special way to get there. Would it have happened if the Judge Advocate General hadn't also wanted to know the answer? No, but it will in the future. So we're continuing to evolve it, but it's an example of advocacy, including legal advocacy around rights. Okay. I've gone on over my 50-minute mark, which I'm so sorry for, but we're going to take a 10-minute break. It is 28 minutes after the hour right now, whatever hour you are. We will come back at 38 minutes after the hour. Okay? Stay logged in and we'll come back at 38 minutes after the hour. Okay, let's get started on this next section. I'm going to wrap us up on some of the substantive pieces in about 15 to 20 minutes at the top of the hour. So I guess 20 minutes. And then we'll move into the scenario. Okay. So I just shared with you what was the first example of a victim having a lawyer in a military case to try to make the rights meaningful. Again, 2013, you can see it in that parentheses when this case happened. So I want to share with you an early case happening on the civilian side. It was only 2 years before. So this movement to have lawyers in the mix is still pretty new. But I want to share this Oregon case with you, not just because I'm proud of it, but because it shows the scope of what can happen when we partner for advocacy around rights to make them meaningful. Again, let me just have someone tell me, I'll explain it. So, State versus Barrett, right? Remember how you read this? So, this is the state versus Barrett, which Barrett was the name of the accused in this case. 255, volume number. P third means the Pacific Reporter third. It's the book. It's on page 472 in Oregon in 2011. So the victim in this case was a victim of domestic violence and stalking. The domestic violence had happened over a long period of time, not surprisingly. The survivor had finally been able to be surrounded by resources that she could access in a way that she felt safe. And so she left the relationship, right? And that's when the stalking began, or began in earnest, started to get amplified up. The survivor did everything our system asks of a survivor. She reported, which is incredibly challenging for any survivor, let alone domestic violence and stalking. And when she secured a protective order, including a stalking protective order, which exists here in Oregon, most jurisdictions now have a discrete protective order for stalking. Her abuser violated it, not surprisingly. And again, she did what the system asks. She reported it. So she has now reported not only the domestic violence, but the stalking, and now the violation of a stalking protective order. And fortunately, law enforcement in the county where she was took that seriously. They don't always, right? Took it seriously. And when he violated the stalking protection order, they arrested. Again, doesn't always happen. This individual, who is a domestic abuser and a stalker, is in custody, and the case starts to proceed. He ends up being released on bail. All of the standard things happen. During that process, the district attorney's office here in Oregon worked with the survivor and gave her a victim advocate, which is amazing, right? During that process, the victim was told all about her rights under the Oregon Constitution and statutes, and was given a form where she could check off which rights she wanted, right? She told the advocate, I want all of my rights, but she didn't turn the form back in right away. But she had said, I want all my rights. Those rights include the right to be notified, present, and heard at plea and sentencing proceedings. Very similar to what I had on the screen before for the Federal Crime Victims' Rights Act and Article 6B rights, which are the rights in the military. So the case is going along. And what happens in most cases? If there is a prosecution happening, do most cases go to trial? Or what happens with them? Anyone, like from your own experience, do most cases actually go all the way to trial, or yeah, plea deal, they resolve in plea? Right. So like the vast majority of cases, this went to a plea. And the plea was to a very minimal charge, and no one notified the victim that the plea was happening, or even that it was about to happen, let alone that there was a hearing where the plea was entered and sentence happened at the same time. We have this abuser whose victim did everything the system asked, who then wasn't told about the plea and wasn't heard at sentencing. Historically, at best, this victim might have received an apology, because what could we do? what we could do in this case was the victim advocate said, wait a second, she has rights and they're in the Oregon Constitution. And that advocate was empowered enough in that office, which is astounding, to say to the district attorney, I think we violated someone's rights. And the district attorney, first the assistant district attorney, no, Jamie, the victim advocate wasn't even notified. That was in the chat. She found out when the prosecutor came back from court and said the case is over. And so the advocate said, wait a second, I think that violates the victim's rights. And they went all the way up, and the elected DA, which is so rare, agreed and actually understood that the survivor wouldn't trust them. And so the victim had a referral to a victim's rights attorney, a no-cost victim's rights attorney that NCVLI and I partnered with, who filed papers called a motion with the trial court that said, you violated the victim's rights, right? The right to be notified, present, and heard at the sentencing were all violated. And the trial courts listened carefully and said on the record, I think you're right, but I don't think there's a remedy. I don't think we can fix this. And we, the victim's attorney and NCVLI, said, thank you. Could you write that down? Because we're going to appeal. And we took the case up to the Oregon Supreme Court, and we said, everybody violated the victim's rights, and what we want is the sentencing to be done over. The sentencing was done in violation of her rights, and therefore was not a lawful proceeding. And the Oregon Supreme Court said, yes, that's 100% correct. The sentence needs to be voided and done over because of the apostrophe. That's the power of victims' rights. Now, does it mean that when sentence was done over, she got the exact sentence she wanted? No. She got to have her voice heard in the process instead of being erased, right? I will say we worked with her then to decide, should she execute a safety plan and flee knowing what day sentencing would happen? Did she want to exercise her right to be heard? Like, we worked with her to be like, what choice do you want? Ultimately, she was heard, and ultimately the sentence was increased, and that was upheld on appeal. Again, it's the victim having the voice, having the rights, having choice in what happens. That's the power of rights if we partner advocates and attorneys, right? And I use this slide, so for those of you who aren't looking at a screen or can't access a screen visually, on the screen, it has this little kiddo who's got a scrunched up face, probably a 1-year-old maybe, and it says, are you serious? And yes, I'm serious. Having lawyers in the mix, if they partner with victim advocates, can make victims' rights so powerful that we can compel systems to not erase the victim's voice. It doesn't mean the victim gets the exact outcome they want. It means that they have a voice and choice along the way. And that's where we're moving with victims' rights in the military. Now, some of you might be saying, wait a second, who are these lawyers, right? Where do they exist? How much money will a victim have to pay to access them? There are victims' attorneys across the country at nonprofits that do this work. And then on the screen right now is a pro bono pairing portal where advocates from across the country can become what are known as qualifying or posting entities. And you can post when you have a client in need of a pro bono, which means free or no cost, lawyer to help with their rights in the criminal legal system, both military and civilian. We are recruiting always more lawyers. This project that we're working on with NAVRA, that we're working on with NOVA, we are trying to grow an increased pool of no-cost lawyers specifically dedicated to working with military-connected survivors. And we'll be doing a lot of training with lawyers around that together with Nova. But you can already try to access our groupings of lawyers across the country, right? Because no survivor should have to pay for lawyers either, right? They've already endured enough. So we can take the rights that we passed into law. We can, particularly if we collaborate, make them meaningful in court systems, right? That's what we need to be doing. Another poll for you, right? As we start to think about how to activate these, let's put up poll number 5. And I'll read this one a little more slowly. So for those of you who don't have it pop up, you can still participate in chat. Where and to whom a report of victimization is made can significantly impact victims' rights. True or false? Great. We can close the poll and share the results. I see all of the ones coming in on chat. Mostly true, a few false. And in the online poll, it was 85% true and 15% false. The answer is true, right? The rights on paper don't change, but your ability to access them and to have power and choice over them does. To the person who said trick questions earlier, maybe this was a trick question too. I didn't intend it to be. But I want to go back to what Ava shared and many of you were chatting about. So if we think about the military system, there is restricted and unrestricted reporting. As was shared earlier, restricted reporting is an option that has been set up in the military. A handful of civilian jurisdictions have it also. In Oregon, Ashland has what is called the You Have Options program, which is akin to restricted reporting. What restricted reporting is, you can report, but you're not reporting to law enforcement. You're reporting to a select groups of folks in the military who are authorized to receive that report, but hold it confidential. And you get access as a victim to services, but not to investigation and prosecution. Those services can be mental health, right? So counseling, they can be assistance with kind of livability aspects, also legal. So a restricted report in the military still gets you access to a victim lawyer. Many of the victim lawyers in the military that I work with spend a majority or a significant amount of their caseload talking to victims about the benefits and detriments, right? The pros and cons of going unrestricted, right? An unrestricted report means you get all the same services, plus there will be an investigation that could potentially lead to prosecution, and you lose control. And what I mean by that is others start to have more power in the space. You will have a lawyer, but there will also be a trial counsel, now likely an OSTIC. There will be law enforcement investigating, talking to people, right? Ultimately, there could be a court martial or an administrative board, right? So restricted allows you, and was designed to ensure that survivors could access things that are about surviving, but maybe not about accountability, as someone put in the chat earlier, right? It's more about internal looking. And then an unrestricted report starts to be about the systemic aspect of accountability. In the civilian system, there are some, like I said, some jurisdictions that have something similar, not quite as robust and detailed as the military has. So an additional things that Amanda has put in chat, you're not allowed a civilian protective order or military protective order with a restricted report. You have to go unrestricted for that also. Yes, because the moment you access the system to get a protective order, that triggers it going unrestricted. So from a safety perspective, you really want to be thinking about when you're working with a survivor, like what are this survivor's needs? Where do they prioritize their surviving, right? Do they have safety concerns? Do they have accountability concerns? Do they have counseling concerns? What does the client I'm working with today need today? Because you can start restricted and go unrestricted. And again, most of the lawyers I work with, their clients started with restricted. And then as they navigated spaces, they either decided to go unrestricted or something happened that it went unrestricted. Yes, I love that you put this in the chat too, that sane and safe exams in different states are also starting to do this so that you can access, right, a sane or a safe exam, right, which colloquially has been known as a rape kit, right? But we're having different vocabulary without having to report, but you can have evidence preservation. It's a really important move that we're having in the sexual violence movement to allow survivors to preserve evidence of their assault, but to then also preserve the opportunity of choice of whether they want to move forward in a system that is not always healthy for them, nor lead to the accountability that they are hoping for. Really, where you report, both is it civilian or is it military, and how you report can impact how much power you have, how much of an apostrophe you have over those rights that are written into the law. Again, it's something to know. There's also, again, I'm not going to go into detail. NCVLI has a lot of online resources about this topic in particular, but with whom you have conversations also impacts your rights. So on the civilian side, right, community-based advocates will often have stronger confidentiality and maybe even privilege with a victim, meaning they can't share information. System-based advocates don't have that because they'll have to share information with the prosecutor, and that information will go to the accused. Military-based advocates do have privilege, but it can be limited depending on how things are communicated and with whom. So again, this is not to make you an expert in all of this, but I have to ask questions. We do an exercise, and I encourage it in every community. We do an exercise where we get partners around the table virtually or in person. And you start by like writing down all the people that a survivor might have to or want to interact with in order to survive. And then we map our personal relationships to each of those. Would I be able to do a warm referral, right, to someone? And how close is that relationship? If I don't have a relationship at all, there's no line between me as the advocate and another person. If it's a good relationship, I draw the line really dark. But then I also go back over all those people and try and figure out who has privilege and who has confidentiality. So that when I refer a survivor to someone, I'm first sending them to someone who will be able to give them as many choices to hold their own story as tightly as possible. Again, you don't need to know all of it now. I encourage you, though, to know before I do a referral to Terry, let's say Terry's one of my colleagues, does Terry have privilege or confidentiality? So that if I refer the victim to Terry, Terry could hold their story tight, or would it trigger something else? Because it matters to the apostrophe, right? So getting to another poll here, let's put this one up on the screen. This is poll number 6. Okay, I'll read it, and I know it'll be put in chat too. To make victims' rights as meaningful as possible, who could be on a victim's team? Choose as many as make sense to you. Military-based advocate, civilian community-based advocate, victims' rights attorney, system-based victim advocate, all of the above and more. So take a minute. All right. Let's share these results. I love that this was a trick question again. All of a sudden, I'm realizing I do trick questions unintentionally. I'm sorry. But right, many of you were checking each of them, and then you got to the last one, which was also all of the above, right? And more. Just like Ava ended part of her session on about who all should be on a CCR, a coordinated community response, that's what this question is getting at also. To empower survivors requires all of us. And it requires us being as inventive as possible in our partnerships. So I love that someone talked about schools being involved, and someone talked about the Humane Society, maybe that was Ava, being involved, right? Being as creative as possible to create a team that surrounds the survivor and helps open up choices becomes so important to the apostrophe. If we don't do that, so going back to that Barrett case in Oregon, if the advocate didn't know the rights, or if the advocate knew the rights but didn't know who to call to get a lawyer referral, we would not have had that success, and the victim would have just been left out of the system. But because the advocate knew the rights and knew a lawyer, and that lawyer, what I didn't share earlier is when we were doing safety planning, we collaborated with another advocate as well as a transportation expert to create some safety planning. And all together, we were able to do something for the survivor. So partnerships are the gold standard of victim services as we are working towards empowerment. Now we're going to practice. I'm going to, in your materials, student resource center online is a hypothetical. The opening of the hypothetical will be the same through every session moving forward. So you're going to meet a couple of characters you will work with over the course of the rest of your time in this training. Then each session, or most of the sessions, will have some new facts that get added, okay? So my time with you is I'm going to have to read a lot of the hypo, but just know that it'll carry forward and that you can also read it online. All right, so here is the hypothetical, and I'm going to look at my screen over here because my font is larger, so I apologize for looking away from the camera for a moment, but here is the hypothetical. This entire first screen is background facts. Okay. So service member, which is shortened to SM, Jones, is active duty military. SM Jones is married to Jennifer, who is not active duty or a veteran. SM Jones and Jennifer have 3 children. Micah, 3 years old, Cheyenne, 12 years old, and Dakota, 18 years old. Micah and Cheyenne are the biological children of SM Jones and Jennifer. Dakota is FM Jones's biological child and Jennifer's stepchild. SM Jones is stationed in Alaska and lives on base, and Jennifer and the children live there too. So I'm going to pause. Big picture. We have a married couple, 3 children, 2 of which are minors, 1 of which is an adult, and the adult child is the stepchild. Okay. Next paragraph. A person who identifies themselves only as Jennifer contacts a military victim advocate's office. After an initial screening, Jennifer sets up a time for a detailed consultation with the advocate to discuss reporting options that afford privacy and protection and to learn about what next steps might look like. At that time, Jennifer does not disclose a lot of information in the initial screening, other than the basic facts that they are married to an active duty service member, have 3 children, live on the installation with their spouse. Jennifer indicates during this initial screening that the ultimate conversation may involve details about domestic violence and stalking by their spouse. During this consultation, Jennifer tells the advocate they are scared for their safety and their children's safety, but are reluctant to share details about or report the conduct. Jennifer tells the advocate they are worried that any impact on their spouse's career from reporting could also impact their family. Jennifer states that they're especially concerned about the impact of reporting on the family's finances and their housing and medical benefits. That's a lot of facts. And before I put on the next screen, use the chat for a full minute. I'm going to go quiet for an entire minute. What are all the things going through your head right now if this was all you knew and you had your hat on as advocate? How are you going to help the person named Jennifer? Okay, so I'm going to go silent for an entire minute. This is amazing. So part of why I went silent for a full minute is because it takes our brains a while to process. Part of it is also to really remind ourselves of the expertise in the community, right? The partnerships to create empowerment are evident in the chat. So we have folks who are saying, start with safety planning. We have folks who are saying, start to identify resources around financial. We have start to think about what safety planning can exist, even though the victim is reluctant to report. We have get FAP, FAPs involved, right? The Family Advocacy Program, FAP involved, which is the military, right? We have Chrissy has learn about potential victim networks of support and provide resources and information about reporting options. We have someone else saying safety first, notify Jen of rights, and then VLC options, right? Get the lawyer in the mix. Brainstorming options is the first step to empowerment, right? As a professional, trying to figure all this out so that we can help Jennifer navigate to the choices that they want, right? Or create the ones they need if those aren't already there. And this is the most amazing answer that's in there right now. Don't pressure her or make her feel guilty, right? What are the choices that Jennifer might want? Oh, I love someone put in mandatory reporting. Advise Jennifer if I am a mandatory reporter, right? Because we have some kiddos in here. Someone else said, right, DHS, Department of Human Services, or whatever the equivalent is in your jurisdiction, Child Protective Services, depending on what Jennifer shares next, may have to report if I'm a mandatory reporter, which may be a wonderful thing, but Jennifer needs to know it before she tells us anything. So she holds on to the apostrophe, right? Okay, I'm going to put the next set of facts up, which ground us more in the rights component that I just talked about. Okay, so a little bit more facts. We can skip the beginning part. The first paragraph are the same facts as I've already given you, starting on the second paragraph. So Jennifer returns to the military advocate's office and appears distraught. They confirm that there has been physical domestic violence and sexual violence within the relationship with SM Jones. Jennifer also tells the military victim advocate that SM Jones has frequently mentioned things that Jennifer only said in private conversations with their family and friends, and that they feel like SM Jones is listening in on them without their consent. Jennifer found a, quote, weird-looking device, end quote, attached to their car, which they think is a tracking or listening device of some kind. Jennifer also fears that SM Jones tracks who comes and goes into Jennifer's house through a security system that Jennifer added to the home a couple of months earlier. Jennifer said they needed to move out of the home and take all the children, including Dakota, because they aren't safe. Jennifer fled the home they share with SM Jones and did take all of the children to a local domestic violence shelter. Jennifer and their children now reside off installation. Jennifer and SM Jones are still married, but Jennifer obtained a protective order with the help of a civilian advocate at the shelter. Whoops. Jennifer is interested in pressing charges now and hopes for a quick resolution of their safety and privacy concerns. Jennifer has spoken with the military victim advocate and the advocate at the DV shelter about their reporting options on and off installation, but worries that these options have changed now that they have separated from SM Jones and are no longer living on the installation. They are overwhelmed and want to learn more about their legal options, their rights, and how the systems work. They're hoping to find an attorney. So one of the things that we did intentionally with this hypothetical is put in a lot, because that's what our survivors come to us with, right? And as a community of experts, navigating through a lot becomes our expertise and our job. I know there's a lot in there, but let's start to talk about it a little bit. So, is Jennifer able to access an attorney on and or off the installation? Would they be different attorneys? What are some differences? Before I answer that question, what do you already know about lawyers for victims? My dog wants to chime in, but I'm going to let you go first. Yeah, so this is great. There will be military lawyers, victim counsel, SVC, VLC. There are off-base attorneys. There are not that many no-cost attorneys off-base, so she may have to pay. There is the pro bono portal that NCVLI has that we could try to get Jennifer a no-cost attorney. And when she goes to the SVC VLC, she is a dependent, so she should be able to access one of those lawyers. If one of the branches ends up saying that she can't, they can make exceptions to their protocols and afford services. So if you run into a situation where someone is being denied SVC or VLC access, every branch has authority to afford access to those services beyond the scope of their normal practice. And so you might be able to advocate for it. But Jennifer should be able to get a victim's lawyer in the military or outside the military and in fact could have both. And I want to pause on that because military lawyers for victims cannot go into civilian court. Civilian lawyers can go into both military and civilian court. This matters because if Jennifer decides to continue with the civilian protective order, if Jennifer decides and the case moves in a civilian prosecution, she's absolutely going to need a civilian victims lawyer. Her SVC or VLC could support that lawyer, but can't go into a civilian court. Okay? So having a lawyer partnership is critical. And as a community, we need to make sure we know who's a civilian lawyer and who's a military lawyer and try to ensure Jennifer might be able to access both. Okay, I've already answered number 2. Let me move on to number 3. If Jennifer has previously been assigned a military lawyer, could they represent in the civilian court? No. I just said that, right? So it's really understanding the scope of the services. Again, I don't think or want you to believe you have to become an expert in this. The lesson to take out of these first 3 questions in this hypothetical is I need to know who the lawyer could be, and I need to call that lawyer before I have a victim that might need them and ask, what's the scope of your services? What's the scope of what you can do? Because then I know what I can tell Jennifer myself, right? Oh, Jennifer, this lawyer can assist you with these things, but if you want to go on the civilian side, let's get you a civilian lawyer. Okay. Number 4, if Jennifer finds a civilian lawyer to represent them, can that attorney represent them in a military court case? Yes. And that is one of the goals of this project that NCVLI is partnering with NOVA on, is to build a pool of no-cost civilian lawyers who can represent military-connected victims in military processes. And the reason for that is because not every military-connected person, even if they qualify for an SVC or VLC, wants a military lawyer, even though they're amazing from my perspective. But right, having your lawyer wear the same uniform as the person who hurt you may not feel safe. Okay. Number 5, I'm going to let you totally agree, make no promises as to civilian versus military. It is absolutely no, the victim's going to tell us which is better for them. And they're both incredibly hard systems. And the lawyers in both can be very challenging. I love my profession as a lawyer, but all of us lawyers, we can be challenging too. Okay, number 5, if Jennifer finds a civilian attorney to represent them, can that attorney also represent their children? And then with the same SVC, VLC represent the adult and the children? What are your thoughts? Let's have you put some information. Okay. I wish we were all in a room together because brilliance is coming out in even when you're asking a question, let alone when you're commenting. There was a question about mandatory reporting. It does vary across jurisdictions, particularly around when kiddos are observers of violence versus directly victimized by violence. So it can vary. But to this question, can the same attorney represent all of them? Technically, yes. But as many of you noted, there could be conflicts, right? The kids and the parent may want to do different things with their rights. And they each have an apostrophe, right? Now, the youngest child, who is 3, likely can't exercise their rights on their own. So that kiddo and the parent would likely have no problem having the same attorney. The next kiddo, who's at an age where they may start to be able to understand their own rights and have a voice, that one's a little more questionable. The one who's 18 likely needs their own lawyer, right? Now, Lawyers often can represent more than one person, but we have to go through a lot of waiving of conflicts. We have to have people understand what could happen. And in a domestic violence situation, any intrafamilial violence, it's really challenging because everyone has a different love relationship with the people involved. And having different lawyers can be really useful. Someone put in a guardian ad litem in the chat, or a GAL CASA, court appointed special advocate is usually what that stands for. Those are usually, they can be attorneys, but they have a different job. Their job, a GAL, guardian ad litem, or a CASA, court appointed special advocate. Their job is generally to present to a court the best interests of the person they're serving, not to present to the court what that client wants. The difference is one can be very parental focused, right? What's in the best interest of this kiddo is X, versus a kiddo saying, I want Y. More concrete example, a kiddo in a violent situation saying, I still want to go home with the person who hurt me. That's what a lawyer would have to argue. A guardian ad litem would have to say, it is not in the best interest of this kiddo to go home with someone who's violent. So they're a little different. Okay. Does Jennifer have the same rights in both, number 6, does Jennifer have the same rights in both military and civilian criminal justice systems? And if not, what are some key differences? Has rights in both of the systems, but as I put on the screen earlier, some of the wording is a little different. And then if we're in the state system, it could be even different. So the bottom line, there are rights in both systems. The nuance, I got to go read the law. I got to pull down the right off of the internet or go to that law book and see exactly how it's worded. But what I can say is victims will have rights in every system. Okay, number 7. Is Jennifer able to have a support person with them during their conversations with law enforcement? Yes. I'm just going to answer that. Even when they tell you no, the answer is yes, and we need to advocate for that. Number 8, what are topics to cover with Jennifer to address their concerns? I'm not going to answer that one, and I'm not even going to ask you to answer number 8 right now. This is the one we want you to think about and carry forward to the next couple of sessions. Right? Because you're going to come back to Jennifer, you're going to come back to her kiddos, and you're going to work with them again throughout the scenario over the 4 days. Okay? Just know that you're going to come back to the scenario, so don't forget about Jennifer. As I close out, I want to just make sure you have the contact information so that NCVLI can help you with anything you need about victims' rights. Our job is to support you in doing your job. We can help connect you with lawyers. We can do research for you, right? As a technical assistance provider, we are funded to support you in doing your work. That's how you can get a hold of us. There is also online through this project, a toolkit about working with victims, which I know you will get access to. More information will be coming, but online through this project, we have created additional resources for how you can serve military connected members. And we'll make sure that you get that information and can sign up. It's all free. It's all a part of this project. So we're going to try to wrap you with services so that you can serve. And here are our websites so that you have any information that you could hope for. If you cannot find something you need, our team or the NOVA team will jump in and hopefully get it for you. So you can access all of our resources at no cost. And Ava put in the chat box the sign up page for that toolkit. You just have to sign up. We'll get you access. There's recorded videos. That video we watched at the beginning of today, there's longer versions of it online. And I just want to say thank you as I turn this back over to Ava. You all have been